My name is Watson. I appear on behalf of the person.
Pham, you appear for yourself?
Leave to my phone in person, sir.
Thank you. Now, Mr. Pham, thank you very much for the materials with which you have provided us. We've read them. The only one I have not read closely is the one which you chose to file yesterday. On the scan of it, it doesn't seem to add a great deal to the substance of the previous materials. But if you consider that it does, you might perhaps outline for us in the course of your submissions what you say it does add. As you've seen, you've got 20 minutes in which to make your case over and above what's in the papers. So when the green light's on, time begins.
Okay, I'm here to defend, apply and enforce the Charter of Human Rights and Responsibility. Ask the Supreme Court and the Court of Appeals to hear interpretation of that charter. It's been refused, and I'm seeking leave to do it now as a combined matter on the application of the charter. The matter itself is, hopefully it's clear to this court.
Just a moment, your application is in Form 1 for leave to appeal out of time against the orders of Justice Dixon.
Is it out of time, sir? I don't believe it is.
In any event, leave to appeal from Justice Dixon.
Is it an issue with time?
I don't think so, but leave to appeal from Justice Dixon is the issue. Sure.
So it's an judicial review. So would you like me to refer back to the?
We've read what Justice Dixon wrote.
Yes.
We've read your submissions about what he wrote.
Yep.
So what we're seeking to hear from you is anything that you wish to add to your written submissions as to why you say Justice Dixon was wrong.
I think he's wrong. Well, I believe it's wrong because he refused to refer to the substantial matter, which is basically the interpretation of the charter. We don't believe VCAT registrars have the power to decide a matter under Discrimination Acts or the Charter. It amounts to an abusive process, and it looks like it's a breach of natural justice and democracy, basically, for the administration of a tribunal to decide the substantive matter that should be heard on wider in front of the prescribed judicial officers.
You mean the registrar had no power to refuse to file your application?
That's correct. And even if he does have the power, he has to give reasons which we don't have at the moment, amounting to...
But wasn't his decision reviewed by the member, Mr. Day?
Miss Day. Miss
Day? And didn't she give reasons for the review?
We reject her reason on the fact that if there's immunity, judicial immunity for VCAT members which were not listed as parties to proceedings, then it comes back to the section of whether it is in good faith or not. So, in other words, I had the right to challenge good faith, and I had the right to present my case in the proper manner, through the proper channel.
Or Miss Day, or what?
Before any court. In other words, the registrar refused my application and deprived me of fair hearing pursuant to the Charter, which is application and reinforcement of common law practices anyway. In other words, I've been denied a process where I can be heard properly by the registrar of VCAT in the first instance. What Ms. Day applied was a judicial immunity for VCAT members, as evidence for my substantive matter. Even if they have immunity, there's a section it says they should have in good faith. So in other words, they had to apply good faith to their judgment. And I think I'm within my right to challenge that.
No, I follow that. And you did challenge it before Justice Lansdowne failed before her,
Yes.
Then you appealed from her dismissal of your challenge
Yes,
to Justice Dixon.
that's correct.
So the question comes back to what is it that's wrong about Justice Dixon's reasoning?
Reasoning, he failed to accept my affidavit against Justice Lansdowne on procedural matters. That's the first instance, and
All right, let's put that to one side. That's only procedural.
well,
What about the substance?
the substance, he failed to enlighten us. Basically, he failed to interpret the charter in the fact that I should have gotten a hearing in the first instance at VCAT, and that judicial immunity only applies to judicial officers who apply good faith, which I'm entitled to question.
Of good faith. Registrar of the VCAT, is that it?
I always say Member Day erred in not applying that.
I understand that, but you say that it was the registrar that lacked good faith when he refused to accept your application, do you?
Yes, without providing proper reasons.
It's the lack of reasons that evidences the lack of good faith, is it? Is that the way you put it?
I'm saying that Justice Dixon did not take into account the fact that the Registrar of VCAT failed to provide reasons to apply a rule that denied me proper hearing, representation pursuant to the Charter, Section 8 or Section 24.
Okay, well just pause there. Let's assume you're right about that the registrar was in error in failing to give reasons.
Yes,
After that, there was the review by Ms. Day.
yes,
The review is a re-exercise of the power by the registrar, which means that she became the registrar in effect to do it all again.
Yes.
She did provide reasons,
provided reasons that they had immunity
right?
and that I cannot prosecute VCAT members, which I was not attempting to do. I named the Attorney General and Department of Justice.
Yes.
So she erred in considering that, and she applied immunity, which I'm entitled to apply a challenge of good faith.
So Day erred in applying immunity. Dixon erred by holding that it was open to Day to apply immunity.
I looked at his judgment. I don't see it. So his judgment seems to be an error of law, basically.
What do you say his error of law was?
Well, he failed to apply. He failed to consider relevant materials in front of him, which is namely.
Lansdowne affidavit, do you mean?
Yes, Lansdowne affidavit goes into a little bit of it.
He was doing it again what just it didn't matter what had happened. It was a fresh hearing or a hearing de novo as we call it.
Yes, I was new at the time and I was a little confused on that fact.
Well, that's all right. Surely he was right to say that because a hearing de novo.
We questioned him that, he didn't answer. Apparently the rules have been changed now, so I'm a little bit confused.
At the time you did this one, it was a hearing.
I'm going to apologise, I didn't know the facts.
With that.
We asked him that. He
explain to you now the reason that Justice Dixon rejected the affidavit is because it was then a hearing de novo, and therefore what had happened before Justice Lansdowne was really wasn't relevant.
Well, the written submission might have had some relevant material on it.
Written submission.
Yes, written affidavits and so forth. In front of Justice Lansdowne would have had relevant material.
Oh, which he had those affidavits, the ones that had been before Justice Lansdowne was material that Justice Dixon took.
Apparently he didn't. From his judgment, he says he ignored it, and he would not entertain it, I believe. That was his...
But this is the further affidavit, wasn't it?
Well, only about what had happened.
Well, that affidavit might have asked for referral to the Court of Appeals on the Charter of Human Rights.
He refused to do that.
Yeah, well, he refused to do that. Seems to me that's an error of law in itself. I'm not sure he can do that under the Charter. He did. The question now is is where interpretation of the charter is sought from the justice. He refused to answer it, and then he refused to refer it to the Court of Appeals. That's a gross violation of statute, I would assume.
I might regret this, I probably will, but I'm going to ask it anyway. This all started with the garage, did it?
Yes. So you're aware of the
In the
background?
VCAT.
That's correct.
And an order was made for possession, dispossessing you of the garage.
That's correct.
Did not appeal against that order.
I did. It's been through here.
Right, and what happened to that?
Took it up all the way to the High Court.
And what happened?
They've rejected it, but we might seek a referral again.
So you appealed against the possession order, but you failed in the appeal. Is that it?
That's correct.
So having so failed, you then instituted this discrimination complaint, did you?
I thought the conduct of the VCAT members were...
No, just getting the timing. It's because you failed in the appeal that you then instituted the discrimination application?
No. During the process, I thought the VCAT members were not acting according even to their charter, the VCAT charter. So I instituted proceedings against the Attorney General and the Department of Justice for failing.
What was the nature of the discrimination?
Well, I feel that they took into consideration that wasn't fair on my behalf.
But what? What did they take into account, do you say?
Well, you've got to have a valid notice to vacate before you apply a notice of possession. They haven't done that. There's further proceedings regarding that. So I feel that I've been denied judicial fairness.
Because they held against you on the possession application, is that it?
Because they failed to apply the Residential Tenancy Act.
Right.
Because under the law, you've got to have a valid notice to vacate before you can apply for possession.
And you argue that the possession...
I argue the notice to vacate was invalid because they didn't file it. And they had no right to a possession order with VCAT, and they had no hearing on that, and they had no judgment on the notice to vacate. If there's no notice to vacate, I'm within my right to stay at the premises.
Were there reasons given?
Yes,
So
definitely.
it was granted?
I disagree with it,
Yeah.
and I appealed to this court and rejected it without considering the facts and considering the charter again.
Right.
Just as Dixon has refused to consider the charter.
And then you went to the High Court?
Yes.
Did you? And what did they say?
They said they didn't give me leave. They didn't give reasons again, so I need to...
But this court
They're allowed
usually
not to.
gave reasons.
I'm sorry?
This court gave reasons. Would you seek leave to...
Their reasons are superficial. They didn't refer to...
Reasons, but you don't agree with them.
That's correct.
It's a fair way of putting it.
Discrimination ultimately is because the VCAT held against you on the possession application, because they did not take into account or give sufficient...
I say that they breached the charter.
How?
By
What did they do?
They refused to consider facts, and they backdated orders.
Just a moment, what is the fact that they...
Well, the fact was there was no valid notice to vacate.
That's it then. It's because they failed to consider that there was no valid possession notice.
No. Notice to vacate.
All right, notice to vacate, that they discriminated against you, is it?
Pursuant to the charter, yes, by denying me natural justice and a proper hearing.
Did they not have a hearing of the possession application?
Yes, but to give a reasons, I have to be present. She didn't give the reasons on the day. She reserved the judgment.
Yes.
The reason was sent to me and gave me no ability to seek concession as to dates and time. So I sought a rehearing on it, pursuant to Section 120 of the VCAT Act.
And I take
They gave me oral submission to that fact, and then they reneged on it. Okay, I apply when...
You sought a rehearing.
Yes.
You applied for a rehearing. And you got a... Did you get...
I had a verbal, oral understanding that the counter staff told me that pursuant to Section 120 of the VCAT Act, I would have a rehearing.
Yes.
They would ring up Springvale Police
Yes.
and the other party to negate the possession order. 2 days later, the police came and I returned the keys. So I've been denying.
I understand you lost, but why is that discrimination?
Well, it seems to me that common law is evidentiary, which is backed up by statute now under the Charter, that I should be equal before the law, I should have a fair hearing. It's clear in the Charter. I'm seeking interpretation, but
I'm trying to clarify, you did...
I've never had a rehearing.
But I thought you reasons were to be seen now.
Member Crimean made an order for possession.
Yes.
No, I never had a rehearing for it.
Okay.
I sought a rehearing.
And it never happened.
It never happened.
You're saying you sort of believed you were going to have a rehearing.
That's the
I got it.
you've got it, ma'am. So what happened was Member Crimean made an order. Heard the possession order.
Yeah.
She reserved her decision, and she handed it down 2 weeks later. Now, basically, the law says I have to be present during that order.
Where did
I believe in possession order. It says the order for the order to be valid, I have to be present. I understand that, but when it comes to housing, yes, I believe. I think the order of possession, when the order is made, you have to be present. I believe so.
You say you're discriminated against, and why Justice Dixon was wrong not to take that into account?
Well, my submission is that the principal registrar of VCAT didn't have the power to deny me a hearing in the first place.
I understand that.
And even if he did, he had to give reasons. Otherwise, there might be misunderstanding.
I do follow that. I just want to make sure that I'm clear that the discrimination which you alleged had occurred was that
I would treat it differently, basically.
failed to give proper weight to the lack of to quit. Or...
Okay, failed to apply the law, in essence.
I see. Thank you very much.
I would also put that there's a defective and incompetent defence that failed to refer to the Charter again by the respondent, and it failed to substantiate any response. And to the last affidavit you're referring to, we seek that the Aboriginal elder Robert Allen Thorpe be added to proceedings pursuant to Section 3 of the...
What's he got to do?
Pursuant to the Administrative Law Act, he'd like to be party to proceedings.
Well, he might, but what's he got to do?
Well, he has standing to be party to these proceedings on the fact that it refers to interpretation of the Charter.
Oh, I see.
And pursuant to the Administrative Law Act, any person who's been affected by a decision... Oh, he's an Aboriginal man, so he's well known, he's been... I apologise for that, ma'am, I try my best.
But I'm trying to...
Believe me, ma'am, I try my best. I tried my best to put in the facts as best as I know it. I thought it was clear, but if it's not, then I'm happy to clarify it for you.
I think we understand, thank you, and we're... Ms. Hobson.
Honours have obviously had the opportunity...
Go through the background, Sarah. Lost the... Didn't appeal as such against that, or did he?
I will just take that. Your Honour, this matter has never clearly been the reference that is in paragraph refers to several effort, strikeout, denial, continuous harassment and victim. I believe this is based on race. And we'll point out that these are in relation to the...
We haven't quite got up to that.
No, Your Honour, yes, certainly.
Landlord and tenant, not the landlord, but the person he appealed against it, indeed to this court, and it was rejected, and he then went to the High Court.
My submission, those that...
I feel a little bit vilified there. You mentioned that.
Then the application registrar refused to accept. Refusal was then the subject.
In person at that. At that time, Mr. Curry...
That review went against the applicant.
And those orders were handed down and...
Pham says, and he may well be recently...
Your Honour, I'm not aware of the residential tenancy. My position, Your Honour, this had nothing to do with the order for possession.
My information.
Yes, Your Honour. And if they're present, May I just
May I speak, sir?
No, Mr. Pham, you have the chance for
no, I can't confirm whether or not Mr.
Then we have the certiorari application and other applications which go before Justice Land, effectively upon the basis.
certainly notes
Then we have the appeal to Justice Dixon. Thank you.
was with was aggrieved by the conduct of the matter he was to seek leave to.
According.
Certainly, Your Honour, and
We have in the materials, I'm not business for decision.
exhibited to the affidavit of Mr. Pham, both Justice Dixon and
But we have them. What do they say in substance?
Your Honour, they go along similar lines to whether or not the Attorney General.
Today's review of the decision of the registrar not to
Yes, and Your Honour, indeed at that point the named respondents were indeed Mr. Robert Clark, the Chief Justice at that time.
Basically just give me the original exhibit.
Thank you, Your Honour.
Thank you, Ms. Hudson, we've read that.
I might now be able to assist you from a note from my instructor in relation to the matter that burned the VCAT possession order made on 30th of August 2000 on Australia's special leave. Third, the section of the superintendent in that proceeding outline why there is no error of law capable in which Justice Dixon acted. Decision is an abusive process or an abuse of vilify Aboriginals, and there is no such no error of law that's been, I think, in my submission, ought to be refused. As the sister honours any further in relation to the point, I can take your honours of the decision of Justice Dixon.
Dan, if you wish, you've got a couple of minutes to reply.
Okay. I'll refer this court to Residential Tenancy Act 97, Section 329.
Yes.
Tribunal must determine application for a possession order under this division earlier than the termination date specified in the notice to vacate. In the notice to vacate, accompanying the application, I submit that that's not been done. I refer to the VCAT Act, Section 120. A review of the order if the person did not appear or was not present at the hearing at which the order was made. So I refer to the fact that I wasn't there when she made the order, and I should have had a chance to reply to that order. That's Section 128.
You say you weren't present at the
I was there at the hearing, I wasn't there when she made the order, and I wasn't given the ability
So
to...
you were there at the hearing?
I was there at the hearing. She reserved her decision, and under Section 120, subsection 1,
120.
yes, have to be, looks like I was not represented at the hearing at which the order was made. Now, however, my concerning is the conduct of Dixon J. I refer to Tomasevich and Trevor Gleaney and Anna. Every judge in every trial, both criminal and civil, has an overriding duty to ensure that trial...
Let's back up at the moment. Whilst we're on your failure to be present when the court a review of that decision
Yes.
was presented,
And I was denied.
and that was because you'd been given...
Yes.
Yes, yes.
Yes, I'm referring to Tomasevich and Trevor Gleaney and Anna. VSC 337.
Yeah.
Every judge in every trial, criminal and civil, has an overriding duty to ensure the trial is fair. The fair trial is only a trial a judge can judicially conduct. Okay. Now, as you're aware, I wasn't aware that hearing in front of Justice Dixon was a de novo. I tried to ask him that and he refused to answer either way. So in essence, I rely on my submissions on error of law. However, I was seeking to challenge the decision of Associate Justice Lansdowne. I believe Justice Dixon has contravened the decision of Justice Bell in Tomasevich. So refer to Neil versus Not, of the High Court, ALJR 509 at 510.
Justice Dixon has contravened the fundamental principle.
That's correct. I tried to ascertain it was de novo or it was a challenge to the conduct of Social Justice Lansdowne.
And Justice Dixon's done it on both bases, has he not? To say he's dealt with it de novo.
I don't believe so, because there's nothing referring to the conduct of the VCAT registrar or the decision of Anna Day. I refer to Neale versus Knott again.
Well, just the point here is that Justice Dixon's made an error by treating it as if it were a new proceeding rather than de novo. Is that it?
In his decision, he doesn't seem to refer to anything, to be honest.
But what's your submission?
My submission is he failed to consider the relevant material, which is the conduct of VCAT registrar and the conduct of the VCAT member Anna Day. And the rest is as written, but we're seeking the writ of mandamus. Rely for an abuse of discretion where discretion has been exercised arbitrarily and capriciously. Or we believe that's the conduct of Justice Dixon.
So you're
No, I'm compelling him to consider the charter in his decision where discretion has been exercised in bad faith. That's Beavers and Co versus Cochrane. In such instances, abuse amounts in fact to no discretion. Mandamus is warranted where the abuse is clear and results in manifest injustice. I mean, the chart is clear. To me, it's clear. And mandamus will lie when an official refuses to act when he has a duty to act and refuses to do so, according to Justice Bell in Tomasevich and Trevor Cleany. That's my submission. Thank you.
Thank you very much. I propose to reserve our decision to the points that have been made orally by Mr. Pham. The judgment at 2:15 this afternoon.
Can I quickly add that Justice Dixon took 6 months to hand down his decision? Part of your submission, sir? Decision?
Then now please until 2:15.
All stand, please. This honour court stands adjourned and will resume at 2:15. Ladies and gentlemen.